The 13th of August 2023. This is on Senator Tim Lombard. He gave an RTE interview, and this is the third video I've made responding to it. And it's under planning law. And Truth Please and two other people suggested that I was over the top in my first video about Senator Tim Lombard and his interview, where he said it doesn't make sense that somebody from far away can object to something to do with planning. Now, the government may try to amend the Planning and Development Act. Whether they can do it for ordinary development, such as the building of a house or that, I'm not sure. Certainly, I wouldn't be getting involved in ordinary local planning under the Planning and Development Act in any far away from here, down in Cork or Kerry or anywhere else. I'm talking here about where it's a government planner programme or part of a government planner programme. Then the SEA directive, the Strategic Environmental Assessment Directive 201/42 EC, clicks into place, and there are a number of industries named in it: forestry, fisheries, transport, town and country planning, energy, river basin management, and there are a few more. Now, I understand, I didn't hear the interview, but I understand that Senator Tim Lombard was talking about building houses. And if the building of houses is part of a government planner programme and they lay out the finances for it, then an SEA has to be done, and it has to be an environmental report completed. That's the law since 2004. Normally, in that case, the government would do it for the overall planner programme, and they'd leave the finer points to be done by an amendment or a modification of the environmental report by the local authorities, and they can do that. Now, there was a case in the courts in Dublin where 416 homes were proposed to be built, and I think are being built, up in South Circular Road, near where the Player Wheels factory used to be. And there was a court case over that, but the local authority, the Dublin Corporation, did do a strategic environmental assessment, and they did do an EIA, an environmental impact assessment, on the local project. So that shows you that they thought it necessary. So if it's a council-based planner programme to do with their county, in my opinion, provided it's not it's not getting government funding, the council could do it. But if it's a central government planner programme, it has to be the Irish government does the main part of it, and then there can be modifications to it at county level to amend it a bit. But what has happened in the case of the wind energy industry, which needs an SEA, is that there's no SEA at all for any of the plans or programmes. The Belgium courts have found that the guidelines of 2006 in Belgium, which are identical nearly to the Irish ones, are illegal, that they have never been properly assessed in relation to the distances from houses and all to that, and shadow flicker, and therefore they're unlawful, and any plan of permission granted using them must be struck down and quashed. But it went further to say that any wind farms already built that were built without compliance with the law must also be taken down and dismantled and the plan of permission revoked. And there's no way out of that. There's no back door of fixing that. Okay, so that's the law, and I only mention it in relation to wind farms because it's an example of what can happen. And indeed, don't forget, in respect of wind farms all over Europe, they're built by private companies. That does not absolve the government from complying with the SEA. It doesn't matter whether they build them with their own staff, board of works, or anything else. Once it's done on their behalf, that's it. If they provide the finance, that's it. There's no way out of that. Now, there's a case, as I said, in the court, going to the court in justice in Europe by the Friends of the Irish Environment, saying that this should be done for Ireland's renewable energy and other things. And we have two cases going in there that I had a little help bringing in there with Sweden and Holland. So this is coming all around them slowly but surely, and it takes time. Now, with town and country planning, it's the same. If they want to build houses for people to comply with the directive, and if they fail to do it, and they try to build them just as ordinary developments, then those houses have no planning permission. And if you're buying a house, the first thing you should do is check who owns the land. Is the title proper for the land? Is it settled? Is it in the ownership of the person selling it? or is there other people can claim it, or whatever. It's up to them to get the title right before they offer it for sale. Has someone a right of way through the land? That has to be sorted and agreed to before it's sold. The next thing is there planning permission? There was a report in the paper last week. A lot of homes and buildings have no planning permission. Is there planning permission? If there's no planning permission, then you're stuck with an unlawful development. And once you own it, it's your baby. The next thing is the mapping right? Is the map correct? You're buying what's on the map. If the map is not correct, it's up to the seller to put it right. So you get a housing estate down in Cork built under ordinary plan and development, when in fact it was funded by the government and funded by Cork County Council, and they did not comply with the SEA directive, and they go ahead and they build it either with an EIA on its own or with no EIA, just planning permission, and the next thing, those houses are put on the market and they're sold. If the lawyer for the buyer is doing his job, he will immediately see that they do not have planning permission, and it would be stupid to invest your life savings or take out a mortgage to buy that. It also, lenders should check that. That's illegal. If they give loans on that, they're not being honest and faithful to their shareholders. They're giving money to something which may have to be pulled down. And auditors and accountants are obliged in their annual report and their annual accounts to state if there's anything to affect the going concern principle. In other words, if there's a problem with planning, that has to be stated in the annual report of the company. And the auditors have to do the same, and it's not done. And the Irish financial regulator won't insist on it. I might give him another writing to, but I know he won't do it. But that is the situation, and any person can go into court under Section 160 of the Planning and Development Act and force it to be taken down. And you think that won't happen? There are all kinds of twists and turns, and a young couple will say, buying a house, say it's a young couple just for example, or a person going to retire and they like that house, they need to be very careful. They need to be very careful. There's enough a hassle trying to rear a family and everything without getting a letter to say you've no planning permission for your house. And you can't get planning permission retention because that's the Derry Bryan wind farm. You cannot do an EIA and an SEA in retrospect. The European Court of Justice has made it clear. If you don't get it right, down it comes. There's no going back. There is with ordinary planning permission. Ordinary planning permission. You can get retention planning permission. But there's not if there's an EIA needed. The government tried to change that and they weren't allowed. Now, what is the government going to do? What's Senator Tim Lombard going to press and recommend? Is he going to stop the likes of me having an objection? Is he going to stop me having the right to public participation and the cost protection order? It may be that he thinks he can do these with ordinary planning, and they can amend the Planning and Development Act to say that only people locally can object. I don't think that will wash, to tell you the truth, but remember that there's three types of development. There's a public planner program which needs an SCA. There's a project which needs an EIA, and the project, if it's part of a government planner program, has to be first backed up by the SCA. So the SCA, the EIA, and then the Planning Act. So you have a planner program, a project, and a development. Now, they might be able to change the law on a development to stop someone from up miles away objecting to a house or a garage or something. They might just be able to do that. I don't know. I don't have to go there. But if it's a big estate or anything like that, supposing they're building 50 houses, it needs an environmental impact assessment. It needs an EIA. If it's a private company doing it and they're going to sell the houses. If it's a government-backed planner program, and even if they decide that they're going to buy these houses once they're built, this could be a let-out if it was challenged. Those houses are dodgy. If you buy a house which the government supported and is part of a planner program for housing and town and country planning, then it could have no planning permission. You don't want that hassle. It should be done right. And I'd hope that will make my position clear. And people see me shouting at Senator Tim Lombard. He's a member of the Oireachtas. This is the law of the land that he brought in, his party brought in. So I shouldn't have to apologise for insisting that it's obeyed. and it has already worked. I mean, we've blocked a heap of wind farms with it, and I'd say the pylons are on the back burner over this as well. It shook the whole authorities when they realised that the law not only is that they have to have the planning permission annulled if it's just after being granted, but if the thing is built and up 10 years, it still has to be annulled and dismantled. That is an unbelievable ruling. It's number 20, C 2419. I'll just stop here. Here it is now with a marker. My marker's getting a bit dried out. C 2419. You simply go into the Court of Justice of the European Union, you search for a judgment, you put in C, and there's a stroke like this. Sorry about that. There's a stroke like this in it. C24 stroke 19. That means the case is number 24 of 2019, and there you'll get it. It's Dutch language, which for Irish people or English people is hard to read. But just go down a bit, you'll see the Dutch writing, and you'll see the reference to wind farm. Once you see that, you just go on down to the bottom and look at the black writing at the very end, and you'll see the ruling there. And if you want to read back up to it, that's all right. Essentially, if it's meant to guide planners, it comes under this, and the wind energy guidelines are meant to guide planners. But this is the same, any guidelines for the building of these houses or anything to do with it requires an SCA. And so it's a serious business, folks. And I don't think that my attitude to Senator Tim Lombard is over the top, because you don't want a young couple, or you don't want the owner of a house or an old person or any person to buy their little dream home, be happy in it, and to have hassle over planning when that can be done right from the very beginning. We're in the EU long enough now. This has been the law. It's there just because the government thinks they can avoid it. They can't avoid it, and that's my point. Comply. I made the point already. A pub has to have a license. No matter what's going on in the premises, if it's not a licensed premises, the Gardaí cannot do anything about it. If you build a pub and you don't get a license, you can have all you want going on there, and the only summons that can be issued is to the owner for running a shebeen or an unlicensed drinking premises. It has no license at all. It doesn't. None of the regulations apply to it. None of the things that built up on provisions over years and years about licensed premises have any significance. It has to be shut down. The Gardaí can prosecute, and it has to be shut down, and not until there's a license granted does the Intoxicating Liquor Act provisions about all the things that's there, about allowing children on it, about after hours and all that sort of stuff, and paying wages on it. Not until that is the case does it click in. So that is a simple legal provision. That's a simple legal provision. You have the SEA, you have the project underneath it, and you have the EIA, and you have the EIA as the project, and your Planning and Development Act. You have a planner program which needs an SEA. You have a project which needs an EIA, and you have a development which is like an ordinary house or building a cattle shed or something else. If the project is part of a government planner program, it must be covered by an SEA under the SEA directive. This is under the EIA directive. And the wording of the SEA directive is that the environmental report sets the framework for future planning consent for projects under the heading of the SEA. It couldn't be simpler. Why they're not allowing this, why they're going to let it go to the wire, I don't know. I don't think there's anything excessive in the way I tackled it, and I'm appealing to politicians and senators now to ask this question and ask the government what to say. Their defence in the case of Friends of the Irish Environment was it's only a budgetary scheme. That won't wash. Budgetary scheme is where you don't start building blocks. You can have a budget for health, you can have a budget for education, but if you have a budget for anything where you interfere in land or works the land under the Planning and Development Act, then that's government subsidisation and government promotion. It's a government planner program, and immediately, if it comes under the industries mentioned, which includes town and country planning for housing, it needs the SCA. That's all I'm saying. Otherwise, you could have a nightmare going down the road It is unbelievable that it takes someone like me to point out that they have to comply with the basic law of the land. Folks, that's to do. Give me a thumbs up, please, or a thumbs down. I hope I didn't leave anything out. It's a serious situation. It is a serious situation that a government, a civilized government, so-called, does this and breaks the law. This is the law going back a long time, and it's built in. It can't be changed. They may be able to change the Planning and Development Act in some way for housing, single housing, for like the likes of walls or building bridges. They might be able to keep the likes of me out. But once it's an environmental impact assessment is needed, an EIA, Article 6, which is there because of the public participation directive and the Aarhus Convention, means that I have to be allowed to make my submissions and partake in the whole process. And the same applies to the SCA. Not only that, if it's near the border or near another country, neighbouring countries have to be told under the ESPO Convention, and there's a Kiev protocol, and there's various things like that, and that has to be all done, and the various stakeholders told, and the public have a right to participate. That is built in law into it. Not only that, but the Aarhus Convention sets out how you help people participate if they don't have internet or they don't have computers. You let them write in, make their observation. The whole idea is to promote the participation by the public in the development of the country, and that is a very good thing, and it's part of our law, and I'm simply insisting that that be obeyed. Thank you very much, folks. I hope that clarifies my position. We're going to stick them on this now big time. We'll see what the Act brings out, and after that then I'll let you know what's happening. Thank you very much. Bye bye.